Good day to all our guests today, wherever you may be in the world. My name is Gordon Harris from the Gowling WLG Global IP Leadership Team, and I'm delighted to welcome you to the 6th webinar in our series, The Life Cycle of a Smart Idea. Up to now, we've been looking at establishing the intellectual property rights base, whether it's patents, trade secrets, copyright, or whatever. Last time, we looked at enforcing trade secrets rights in the wake of a blatant theft. If you'd like to catch up on any of the earlier webinars in the series, they're all now available on demand at our website or at our dedicated IP platform, goexcel.gowlingwlg.com. This time, we return to the world of patents and start to look at the strategy and tactics as the game begins. This is the first of twin webinars, first reflecting the perspective of the patent owner, and the second next week, looking at these early stages through the eyes of the defendant. We're going to do all this against the backdrop of a scenario based on a globally patented invention, attracting envious interest and inevitable imitation. To illustrate the issues, we'll be calling in at our offices around the world to hear from experts with enormous experience in national and multinational patent litigation. So let me introduce our panel to you. First up, let's start in Calgary with Patrick Smith. Patrick is the leader of the Calgary office's intellectual property group and a registered patent agent. He provides strategic patent and life cycle advice to clients in the oil and gas, pharmaceutical, agriculture, biotech, and chemical industries. Over the last 20 plus years, he has appeared as counsel in more than 100 reported decisions relating to patents, trademarks, and copyright in the Ontario Court, Federal Court, and Supreme Court of Canada. Alex Brodie is in our London office. Alex is head of our UK patent practice and co-chair of our global firm's tech sector. Her practice is focused on multinational patent infringement and licensing disputes, usually in the SEP-FRAND arena. She has secured a number of firsts in litigating patents on behalf of her clients, such as the first immediately enforceable injunction in a standard essential patent case post-trial, and the first finding of essentiality in the UK courts. Client feedback describes her as a great strategist and tactician, and as well as extremely bright, highly knowledgeable, and a pleasure to work with. Well, we'll all be the judge of that. But over to Paris then, where Clémence Lepotre is waiting for us. Clémence is specialized in intellectual property and information technology work. Her expertise notably includes patents, trademarks, and software work. She's built up considerable experience in litigation, including in complex and multi-jurisdiction disputes, as well as in the enforcement, management, and licensing of IP rights, search, clearance, risk assessment, opposition proceedings, and settlement, as well as, of course, license agreements. Moving on then to Munich, we will meet Jonathan Kernitz. He advises on intellectual property law with a strong focus on patent litigation. His wide range of experience includes patent disputes in various technical fields, particularly telecommunications, mechanics, and electrical and medical engineering. Through his work on numerous high-profile standard essential patent FRAND cases, he has also developed in-depth expertise in patent-related antitrust law and cross-border licensing negotiations. Now, Jamie is currently based in London, but has actually been in China for the last 4 years. He led our Guangzhou office and has extensive experience of all aspects of the court system in mainland China, and he understands the complexities and cultural challenges very well. His very significant experience enforcing and protecting intellectual property rights in both global court disputes and international arbitrations, both institutional and ad hoc, advising clients in the aviation, automotive, medical devices, consumer electronics, and telecom sectors. Last but by no means least, Alexander Christoforov is waiting for us in Moscow. He's been a partner in the Moscow office for 10 years. His practice includes litigation and appeals on the entire IP spectrum and unfair competition, as well as trademark prosecution. His numerous court cases set many precedents, including in the highest courts of Russia, the Supreme Court and the former Supreme Commercial Court. He says that in the last century, he was general counsel of the Russian Patent Office, and I wonder what he's planning to do in the next century. So let me set the scene for today. And today, I'm in an interesting and different position. I'm the client. I'm the managing director of Tidecore. Tidecore is a company based, involved in sustainable energy creation and storage. It has developed a revolutionary new method of storing electricity underwater using tidal flow, buoyancy, and predictable currents. The potential is global, so realizing the technology would be clearly visible in use, we opted for a global patenting program, majoring on coastal countries and big energy users. The countries covered include Canada, the USA, Russia, China, and Europe. As a hedge against possible complications following Brexit, we did not designate the UK in the European patent application, but took out a separate UK patent. Now, obviously, as we all know, this was probably a mistake. It's not strictly necessary because, as we now realize, the EPC is not a piece of EU law, but we are where we are. Our technology involves using resistance to water flow and the buoyancy of large air-filled containers to first generate and then store electricity. The mechanical construction required to do this is always located close to land and cannot function in deep water. Although there are similarities between the patented technology and known tidal energy generation technology, we, the patentees, have persuaded patent offices around the world that there is enough originality in our technique to warrant the grant of a patent, though it took some years of office actions and a lot of money. The core patent is under opposition in the European Patent Office. It was amended after the first round of the process before the opposition division, which it survived as amended, and there's a pending appeal to the Technical Board of Appeal. The technology was an instant and highly profitable success, and there's been substantial demand for investment. There's also been substantial interest in imitating our process. What a surprise. We've identified infringements all over the world and are actively considering the possibility of commencing proceedings in North America, Europe, Russia, and China, as well as Brazil and Australia. We're concerned by the erosion of the uniqueness of our invention, and we're keen to make a strong stand in at least 1 or 2 jurisdictions, possibly seeking immediate injunctive relief. Each of our infringers is unique, and they're not part of a group company. To assist in the process of deciding where might be the best place to start proceedings to gain the most immediate impact, the TideCore board have asked me to identify a global strategy, pinpointing the benefits and possible problems involved in starting litigation in each of the jurisdictions where we have found infringements. Now, knowing that Gowling WLG has strong global coverage across many of the countries I'm interested in, I've asked them to give me a global view. And I've gone to 2 lawyers there that I know well, Alex Brodie in London and Patrick Smith in Calgary, and asked them to take the lead, both in respect of their own global offices and also firms in other countries where Gowling WLG do not have offices. So let me allow them then to introduce the topics and talk for me, and I will be looking forward to receiving their advice a little later on. Patrick, I think you're going to kick us off, or is it Alex? Perhaps Alex is going to kick us off.
Thank you, Gordon. So, really interesting problem that TideCore's got on its hands, and there are a lot of options available to it. But that's not really the point, is it? A lot of options is all very well, but you've got to identify your goals. You've got to know what you want to achieve and how important it is. So we'll be looking at how we can narrow down and deliver what TideCore need for their business goals. But we've also got to bear in mind we've got this potential problem in the background, haven't we? Because Gordon told us that they've got a pending technical board appeal decision coming. And this could, at its worst, knock out the patent entirely in continental Europe. It'll leave the English patent alone because they went for a separate patent right. But depending on the nature of the attack and the decision, it could affect the validity and how we approach the rest of the patents in the portfolio. So that's one to bear in mind for later. Okay, so Gordon told us that they want to sue, and they want to sue everyone, everywhere. But is that really the right decision? It's going to be time consuming and cost consuming. However, let's take a look at Gordon's options. So 4 things I'd like to mention on infringement. First one, maximum impact. Sue each of the infringers on the same day, crucially, in each of their local countries. Maximum cost, maximum time, but huge show of strength will rattle the industry at large. So highly efficient in shock and awe, also highly efficient in emptying one's pockets. Surgical impact might be better. Pick the most high profile or the most voluminous infringer in the friendliest jurisdiction and sue them hard. Engage in effective PR and let the remaining infringers start to worry. If you can secure an early victory through an interim relief procedure or a quick jurisdiction, use that early victory to drive settlement So you secure an anchor tenant with maximum PR, and at that point, you approach the rest of the market from a position of strength. Third thing, mixture. Because this is so spread out globally, it might be that to create maximum impact, you need a surgical approach, but in maybe 2 or 3 jurisdictions to ensure globally that your strength is being felt and you're not being written off as just a UK company or just a European concern. So it might be you need to go more than one continent. Then the fourth thing, nothing to do with IP rights, additional attacks. Think creatively. Is there any other way you can unseat your infringers? Are they breaching environmental regulations? Do they have relevant permits for access to the coast to do construction there? Can you get them in any other way? So you come at them sideways whilst also hitting them for patent infringement. So that's the litigation options. Gordon told us they're bloodthirsty and they want to sue, but we should also just challenge that with a client and say, that's all very well, but what about the money? You said you didn't want a pot of gold, but if there is one, do you really want to throw it away? So should we be taking a look at encouraging the client to think about their possibility of licensing their infringers and turning them from a problem into a revenue stream? So should we be putting in place a non-disclosure agreement to open up licensing discussions? Should we be considering inviting them to arbitration? There's going to be a big topic of arbitration addressed in one of our forthcoming seminars by our international arbitration team. So I won't mention it here, but what I will say is it's hugely effective in multi-jurisdictional patent disputes. So those are all just the strategies to bear in mind. Sue them hard, license, come at them sideways. But Patrick, it's all very well having lots of good ideas, but how do we just go around like getting hold of this and implementing it in a practical way for the client?
So before we jump into the individual countries, we look at what can be done there. I think it's important to consider 3 big topics that any client should face when they're looking at international litigation. And I've broken these down into 3 categories. One is getting ready for the litigation. What steps should be done before you actually start the litigation? Second one is implementing and coordinating the strategy. And that's very important because as we'll see, any admission that happens in one country will be rolled out and will be used against the client in every other country. Mm-hmm. And the third thing is very important as well, which is client budgeting and client reporting. So how does that take place? And it's important to get the agreement up front. So let me tackle each of these 3 areas first. So first thing is getting ready for litigation. So the first thing we look at is, one is just look at the client's entire patent portfolio. It could be patents or patent applications, because it could be that mistakes are part of the claims. Inadvertently, they made their way in there. So every patent that the client has should be reviewed to see if it's in the best form for litigation. There are steps, depending on the national law that's at play. There may be steps for amending patents or patent applications. That's the first thing. Second thing is getting ready for documents. So the client's going to have a trove of documents that we're going to have to go in there and first identify, collect, sort. That's very important. And so what we'll do is we'll conduct witness interviews with potential witnesses at the client. Our firm has invested in IT that we can go in and scrape documents, electronic documents, and we'll be able to put them in a central repository of documents, or that will have electronic access to lawyers working for the client in whatever jurisdiction they'll have in. And as part of that process, we'll code them based on issue, based on author, based on date. And once we get familiarity, that can be rolled out to all the jurisdictions. So we'll be able to help individual jurisdictions rather than having to learn all these documents again. The firm will be in a position to know what those documents are and how to use them in various jurisdictions. Now, the disclosure requirements in different jurisdictions are different. Canada is part of a full disclosure jurisdiction, and there's a definition of relevance. So what has to be produced in Canada will be different than Moscow or London. We might see a little bit about that as well. And as part of this, one is you're going to be able to potentially identify witnesses at the client's company, but also when you're dealing with fields of technology that are relatively narrow in scope, there may be a limited number of experts. And patentees have the great advantage here because they know litigation is coming, whereas the defendants do not. And if there's only a limited number of experts, now's the time to retain them before your opposition can. And so that's just another thing that should be considered. Now, the next topic that we look at is implementing and coordinating strategies. And that could be done with the Gowlings professionals who are retained in individual countries. We've also got a great network of working with elite lawyers in other jurisdictions where we don't have offices. But what's got to happen is there's got to be a team approach. Because if you've got somebody in a country that isn't playing with the rest and makes admissions, then the defendants are going to know about those admissions and they will be rolled out in every other jurisdiction. So ensuring that there's a consistent message is crucially important. That's the first thing. And the second thing is it could be that we're going to have success early. That's what we want. We want to develop some momentum so that we can keep going. And if we've got that success, then hopefully it will continue. But there could be inevitable setbacks. Litigation is risky. You never know what's going to happen once you go into a courtroom. And so what happens if you're hit with a setback? Are you going to have an explanation about why that happened in one jurisdiction? It could be a difference in evidence. It could be a difference in procedure. It could be a difference in national law. But you'll want to develop one of those explanations so that you can get over that setback in other jurisdictions. The other thing in this category is choosing when and where to assert patent. And we're going to talk about individual countries, but if it's very difficult to get an interim injunction in one jurisdiction, and your goal is to get that early knockout that you talked about, well, then maybe some other jurisdiction should be favored over that one jurisdiction. The final thing is in terms of budgeting and client reporting. Depending on the resources that the client has, just keeping track of multinational litigation could be complex. And so we're able to help with that if the client wishes, so that we can have either one or a few points of contact so that we can provide oversight and reporting to the client. And finally, budgeting. Budgeting is really, really important. So our firm has invested in software that allows us to monitor and analyze the budgetary expenses on particular files. But it's important to reach an agreement with the client about how much things are going to cost and what happens if there's unforeseen circumstances arise in a particular jurisdiction. So those are just some overview things to consider. So now, Gordon, if I ask you, in terms of the goals, like what is the goal of Tidecorp in terms of going forward?
Well, the board's initial view is that it wants to make a statement to the market. We will not sit by and watch our technology stolen. We're not looking for a pot of gold at the end of the litigation rainbow. Our objective is to deter others from copying and encroaching on our market. That said, Tidecorp is prepared to consider licensing the technology in a controlled way, but from a position of strength and hopefully monopoly, and with trusted partners, not necessarily those who have been trying to infringe us. The turnover and profit in our business means that we are willing to contemplate maximum impact, but only if we are assured that we have a good chance of maximum success. So I hope that helps give you a steer as to how the company wants to take this forward in the light of what you've just been talking about. Alex,
yeah.
What do you say?
Thank you, Gordon. That's really helpful. So we're going to sue them, and we need to create, as you said, maximum impact, fast as possible, and then come at things from a position of strength. So I think there are three things we need to identify in the jurisdictions that are open to you, Gordon. One, what options are there for interim relief? So something quick that's going to hurt them. Number two is, what is it about that jurisdiction in particular that could deliver a really good outcome for Tidecorp in due course at trial? And three, are there any bugbears that we should just be aware of when considering that jurisdiction? Because there is no one jurisdiction that is 100% claimant friendly or 100% defendant friendly, unfortunately. So looking at the jurisdictions available to you, you do have two of the jurisdictions that are typically considered to be more tricky or more difficult to engage with than others, China and Russia. So what I think we should do is start there, because they could be great for you given the amount of coastline involved and the fact that your products are all along the coast, and that's where they're being, that's where your patent is being infringed. So can I introduce Jamie to speak to those 3 items in relation to China?
Thanks, Alex, and hello, Gordon, and thanks. That was very, very helpful. So I'm going to start with Alex's second question, if that's okay, which is what would be, or what would I see as the real benefit of going to China for Tidecore? And I think the prize for Tidecore in China is the ability to obtain a final injunction, and a final injunction at a relatively cheap cost, in order to try to stop large-scale infringing manufacturers flooding both the internal market, which of course is huge, but also the rest of the world market via export. Now, I do appreciate the second point may be less relevant for Tidecore because we don't know of any connection between different jurisdictions. It's worth bearing in mind. So that's the prize. But I want to touch on 3 points in relation to that, just so you're clear on the current position of litigation in China at the moment. I think the first point to make is that there are now specialist IP courts in China. It's always been seen as a challenging jurisdiction, but actually these IP courts have hugely improved the prospects for foreign claimants litigating in China. Surprisingly, China is actually quite a claimant-friendly jurisdiction to litigate. My second point is one about neutrality, and you hear a lot about that when talking about litigation in China. The courts are getting better these days, frankly, but one thing we would need to think about carefully right up front is the choice of jurisdiction in China. It's fundamental for Tidecore to get into the right jurisdiction within China. For example, getting a strategy together to try to avoid the defendant's home jurisdiction. And my third point is in relation to costs and timing. I said one of the benefits was that it's relatively cheap in China. Well, for a single patent case, you're likely to go from filing to final first instance decision in less than £100,000, and it could be considerably less than that, depending on the technology. And timing-wise, you're talking 9 to 12 months from filing to a first instance decision. Now, you're only going to get 1 day in court, but for that cost, and given the size of China, there's an attraction to China if we can find the right manufacturer to go for. So turning now to Tidecore's interest in interim relief, and in particular in relation to an interim injunction. I think the first point to note is China probably isn't your jurisdiction. That is what you are after as a sort of short, sharp chop. It is, in theory and in law, possible to get an interim injunction in China. And in fact, our colleagues in China have done that in relation to design patents. But the reality is, particularly for an invention patent, it's extremely rare. But there are other interim relief remedies that you could think about. So for example, it is possible to make applications for evidence and asset preservation orders. And you can do that fairly early on in proceedings. And the benefit of that is that if an evidence preservation order is successful, that can seriously disrupt a defendant's business going forward. So one to consider. So now to the final points. What are the challenges in China? And of course, in a jurisdiction such as China, there are challenges. I'm going to pick up on 2. The first one is in relation to obtaining infringing evidence. The way that the court system works in China is that you do require notarized evidence. And if you're going after a manufacturer, which may require you to obtain that evidence from a factory, that will certainly require the need to instruct an investigator, and it's fundamental. We are there to help you with that, to ensure that private investigator is robust and plays by the rules. But the fact that you do have to get into a factory potentially, and you have to get the notary in, that is challenging. It can be time consuming. And there's certainly no guarantee at the start of proceedings that that will be successful. So you need to factor that into your overall strategy. And finally, And I know Tidecore and Gordon, you've explained the pot of gold is not the end result, but do remember that damages in China remain low. And the prospect of recovering your legal costs is also very low. Litigation in China is not about compensation. If I circle back to what I said right up front, really the goal and your prize is obtaining that final injunction at a relatively cost-effective manner in a very, very substantial market. So that sums up a quick wrap-up of China. Alex?
Thanks, Jamie. That's really helpful. Alexander, do you want to do the same for Russia?
Well, to some extent. So in this respect, Russia is much like China, with Jamie greatly explained. Yeah, it is a very good jurisdiction for litigating patent infringement, just in certain situations. So first, the market in Russia is also a giant one. So if you are interested in the Russian market, then you definitely should go litigating in Russia. Yeah, and if you are just choosing where to start, the litigation in Russia is fast and relatively cheap. So the trial takes like 6 to 9 months, maybe. So it's even faster than in China, and respectively cheaper, since the faster is the trial, the less lawyers work it involves, etc. But the contrast is that first you should have all evidence at hand, as there is no discovery in Russia, and you can't rely on the judge to help collecting evidence, so there is not even evidence preservation orders. You shouldn't expect that. So the judge can only request the defendant or a third party to provide a specific document, not more than that. And interim relief is almost not available in Russia, so you can't expect that. As for the high amount of damages, the situation is like in China, so the very high amounts are extremely rare. So the most valuable price you can get is the permanent injunction, which gives you the market. And for this specific case, the most important factor is that, as I understand, the patent is not definitely valid. Yeah, so that's questionable validity. And to fight with the issues of questionable validity is probably not very appropriate to choose Russia as a jurisdiction, since we have a bifurcation system. So any invalidity issues are tried in a parallel procedure in the patent office, and it is quite strict in what amendments it allows. So it's good if you have just to drop one claim, for example, and keep the other claims, or to make an independent claim, to drop an independent claim and replace it with a dependent claim. Yeah. But when you, for example, want to combine features from a few different dependent claims, that's maybe already a problem. So if this patent is questionable, I would not recommend starting with Russia here. But otherwise, it is still one of the first choices.
Thank you, Alexander. So Gordon, two really interesting insights there. So nothing going on the interim relief, not good for a damages pot, but really attractive from a final injunction quite speedily, with some, caveats around patent amendment and also around disclosure and evidence, but some really good options there. So could I bring us closer to your home, into Europe, and Clémence, can you just explain to us what we could do in France?
Yes, thank you, Alex. France has become indeed recognized as a patent-friendly jurisdiction, which makes it very attractive for Tidecore. But in order to ascertain whether France is a convenient forum in our case, I think that three main topics should be assessed. How Tidecore can obtain evidence in France where there is no discovery procedures, how the proceedings on the merits will be conducted, and can Tidecore obtain interim measures, and how quickly? So let me start with the evidence issue. And in France, like many other European countries, the burden of proof is on the claimant, and patent infringement can be proven by any means. And Tidecore, for instance, can call upon private investigation services. But the most effective measure in France is certainly the seizure or saisie contrefaçon. And with respect to seizure, I would like to emphasize 3 points. How can TIDCORP apply for it? What kind of evidence can be gathered? And the traps that should be avoided. So as per the application process, TIDCORP can request the court ex parte to have the authorization to have a belief accompanied by the relevant experts, in most of the cases, patent attorneys or IT experts, with the assistance of police officers, if needed, enter the premises of the alleged infringer or any third party involved in the infringement. And during that seizure, the bailiff can seize, describe, take pictures of the infringing products or processes used, but also collect any relevant document demonstrating the extent of the infringement and the prejudice suffered by TIDCORP. It includes information relating to the sale network or the quantity of the litigious products sold, for instance. And it can be very useful to support TIDCORP claims, in particular because evidence gathered in the court of a seizure in France may be used to support further action abroad, provided that the seizure order has been loyally obtained, of course, and remain proportional. However, we have to keep in mind that a seizure is an intrusive procedure and therefore is highly regulated. And in this respect, special care must be taken to preserve the potential confidential information or trade secrets of the seized party, who will not, for sure, hesitate to challenge the validity of the measure on this ground if we go too far. So in this respect, the implementation of a confidentiality club limiting access to sensitive documentation to patent attorneys, lawyers, and judges, and therefore excluding the parties, can be a very smart way to prevent a seizure from being invalidated for this reason. I would like to point that seizure is highly dependent on the filing of an action on the merit within the time limits provided by law. And failing that, the seizure shall be void and TIDCORP will be prevented from using the evidence gathered. So this is why my second point will be dedicated to the action on the merits, focusing on time frame. In France, the validity and infringement of the patent are assessed simultaneously within the same proceedings. It can speed up the process since the decision on the infringement will not be stayed if the validity of the patent is challenged by the defendant. Nevertheless, there will be for sure several sets of arguments, submission, and evidence exchanged between the party before the case is ready for trial. In our case, the action should not be delayed pending the outcome of the opposition before the European office, which is a good point, because the stay of the proceedings is only pronounced by French courts when it is in the interest of the proper administration of justice. So the court will assess whether the European Patent Office can uphold the title in its current form or in an amended form, or if the stay is a delaying tactic that can have prejudicial consequences for the patentee. We know that well as prosecutors. So in the present case, given that TIDCORP's patent has survived first instance proceedings, there are good chances that no suspension will be granted by a French court. However, in any event, given the nature of a patent case, I think that TIDCORP may not be able to obtain in France a decision on the merits within 16 months of the seizure. So as a result, TIDCORP may want to seek quick and effective measures using the interim proceeding route. And in France, interim proceedings may be filed either before or after the action on the merits, regardless of any urgency requirement. So judge will simply conduct a preliminary assessment of the patent validity. Second, ascertain whether the infringement is established with a sufficient degree of certainty. And third, consider if there is a significant risk of prejudice for the patentee before granting interim measures, such as injunction to seize the act or the grant of money. And what is very interesting for European country when it comes to interim measures is that they can be requested in one member state in order to have effect all across the EU. In France, obtaining interim measures usually takes 3 months, which may seem longer as a matter of fact compared to other jurisdictions in Europe, such as Germany. And in this respect, I will give the floor to my colleague John from our German office.
Thanks, Clémence. So why consider Germany in the case at hand? Well, it's an important market in Europe. And it's, at least that's what people tell me, a highly respected jurisdiction also. So a decision, you know, might or can have an impact here. And this is, of course, particularly true for European patent. So for the purpose of this initial discussion, I will just focus on TypeCorp's interest in a quick decision to send this strong message early on during the overall litigation approach, because Germany is in fact a good place for this. So in the next couple of minutes, I will give you just some key aspects about the German infringement proceedings on the merits and preliminary injunctions. And both could give us a provisionally enforceable injunction. Now, in Germany, a first instance infringement judgment can be available in less than a year. Because we have a bifurcated patent litigation system, which means that the federal patent court will deal with the validity of the patent, and specialized patent chambers of the normal civil courts will deal with infringement. So the infringement court can issue a judgment while the fate of the patent is still in question. But before we get too enthusiastic about this, to be fair, there are of course things that can slow down the infringement proceedings also in Germany. So in particular, we need to keep in mind that the infringement court can stay the infringement proceedings pending a first instance validity judgment, or at least preliminary opinion by the federal patent court, but only if it thinks that there's a high likelihood that the patent in suit will not survive. Courts are rather hesitant to stay the infringement proceedings because it would basically undermine the bifurcated system, but it can definitely be an issue, in particular if the defendant gets strong prior art that wasn't considered in the prosecution process. Now, the second thing is taking of evidence. If we get to a point in the proceedings where the court needs to appoint a technical expert, then this will significantly delay the case. Which brings me to the next point, preliminary injunctions. They are available in Germany and can be obtained within a few months or weeks, or in very urgent cases, even within days. And when I say preliminary injunctions are available, I don't mean available in theory or on paper, but German courts are absolutely willing and ready to grant preliminary injunctions. And I've experienced this many times. But nevertheless, the hurdle is high and there's a risk we need to be aware of. So in order to obtain a preliminary injunction, when it comes to infringement, we need to have more or less a clear-cut case. So no complex technical issues should be at hand, where a judge wouldn't feel comfortable to render a decision quite quickly, but would think that we need expert evidence, etc. So we need to be prepared and feel comfortable with our infringement story, and it should be well documented. And we could use all sorts, screenshots, operating instructions, photos, and affidavits, etc. But we need to have this sort of stuff to have a chance of success here. The second thing is the validity of the patent and suit must be sufficiently secured, which usually requires that at least a positive first instance decision in opposition or nullity proceedings is available, which I understand is the case here. And thirdly, we need to have a matter of urgency, which means that the applicant must substantiate to have done the best to enforce the rights as quickly as possible after becoming aware of the infringement. And as a rule of thumb, the applicant should not wait longer than a month to react after becoming aware of the act of infringement. So what's the risk of the PI? Should the PI prove to have been unfounded later, then the applicant must compensate the opponent for all damages suffered as a result of the enforcement of the preliminary injunction. So to sum up, there are a couple of things we need to further explore with Tidecorp, but if the goal is to get a quick decision somewhere, we should definitely consider Germany.
Thank you, Jonathan. So Gordon, so far we've been hearing that in France we can go quickly and secure some evidence of infringement and use it elsewhere to bolster a good case somewhere else. And that seems a really interesting idea. In Germany, potential prelim, but I think a really good idea is the quick infringement decision with a persuasive judgment. I wanted to talk to you briefly about the UK, but I appreciate you're quite knowledgeable about this jurisdiction already. A couple of things to mention. Pre-action, preliminary injunctions, yes, available, probably not in this case, unless we're aware that someone's about to launch and we can stop them coming onto market. But if they're already on market, already infringing, we're probably more likely to go to trial, unless we can say that damages won't be an adequate remedy for us. So in terms of preliminary measures, I doubt that's going to be the one for us, but something we might want to bear in mind is a pre-action application for disclosure if there's information documents that we need. The benefits of the UK, the real benefit is it's a big jurisdiction in terms of you will get a fully articulated case here. You will hear expert evidence, your patent will be tested, the infringement will be tested, the disclosure will be there, and you'll get a big judgment that's properly explained and tends to be quite persuasive in other jurisdictions. It'll take a bit longer. We're talking 12 to 15 months for first instance at the moment, and it can be significantly more costly in action in, say, Germany or Russia. But that means it's also significantly more costly for your defendant. They're going to have to take you seriously. This is no joke for them. So if you want to drag someone before the court and cause pain, it's a good jurisdiction to be doing it in. In terms of the EPO, UK court really unlikely to stay its proceedings pending the TBA decision unless it's about to come out on Monday or something like that. Okay, so turning to North America, where I appreciate you've also got issues, Gordon. So Patrick.
Yes, so I'll talk about both Canada and the US, and if I do it at the same time, then it provides a good comparison of the two. So first, both of these jurisdictions are full discovery. The procedures are different, but you're going to get a lot of documents and a lot of information from the defendant in each of the jurisdictions. One of the things, though, is that in terms of the procedure in the United States, a judge will construe the patent, and typically juries will decide whether there's infringement or validity, which is a pretty interesting scenario, given that you know you're fighting about technology in the United States, yet you've got a jury of people who are not technically oriented are going to make those decisions. In Canada, you're going to get a judge alone. So that's the first thing. Now, the second thing is, where are you going to sue within the jurisdictions? And let me just contrast the two jurisdictions. In Canada, most IP litigation is in the federal court, and the federal court sits right across the country. So if you get a lawyer in Canada, whether they're in Montreal or Vancouver or Calgary or Toronto or Ottawa, they're going to be litigating in the same court. And the Canadian federal court basically has electronic means, video conferencing, to help make the country that's geographically bigger, making it smaller so that people can litigate in the same court. In the United States, what they've done is they've broken the country into circuits. And within those circuits, there's districts. And you've got to sue in a place that has a connection to the defendant. And so there's more opportunities for forum shopping in the United States. And there's different success rates for patentees depending on where you choose to litigate. So where within the United States you choose to litigate is an important consideration. Now, the next thing I want to ask about or talk about is the availability of interim injunction. In the federal court in Canada, it's virtually impossible to get an interim injunction in a patent matter where the defendant is solvent. That's just the reality. Very few have been issued in the last 25 years. In the United States, it's much easier. And as we're going to see, much more expensive as well. So what's the cost? So I'm going to use US dollars so we can have a better comparison. In Canada, a budget for a full-blown action, probably $1 million US. That's what you're looking at. In the United States, I think $5 to $10 million would be probably a more realistic budget against each defendant that you're going to go after. If you're going for an interim injunction, I wouldn't be surprised for somebody to quote you $2 million US. So the budgeting part, when we talked about earlier, how important that is, that's a very, very important consideration in terms of setting strategy. We'll come back to that. And then in terms of the availability of damages, it's similar in both places. Either damages or an accounting of profits are available in both places. But it's going to be based upon the incremental value of the invention as opposed to all the profits that are being made by a defendant. And so there's going to be some financial considerations in both jurisdictions, but a monetary remedy is available in both places. So that's that's basically an overview of Canada and the United States in terms of the litigation process. And Alex?
Thank you, Patrick. So, Patrick, I think you were going to summarize at this point, and obviously you'll be noticed that we need to speak to, I think, Brazil and Australia, Gordon mentioned.
Yes, I would like to hear about Brazil and Australia, definitely, yeah, thanks.
Yeah, so we've obviously, a firm like ours has close ties to elite lawyers in jurisdictions where we don't have offices, and that's not the case here. So what we'll do is we'll reach out to our colleagues and provide you a similar overview of the process in each of those jurisdictions, along with a ballpark cost of what that's going to be. So Gordon, here's what Alex and I would like to do. So first of all, we want to take our time and review your patent rights, just to make sure that they're in the form that we want them to be in before litigation. That's the first thing. And at the same time, what we want to do is we want to come into your offices and interview the key people, the inventors, and other people knowledgeable about the development of the invention and the commercialization and marketing of the invention. They could be potential witnesses, and they're also going to help us identify potential sources of documents. And we'd like to bring our IT, when the time is right, we'll bring our IT people in, and we'll help scrape the documents electronically from your databases. We'll put them in a litigation repository, electronic repository of documents, and we're going to go through some coding to basically sort through, summarize those documents in terms of a way that makes it searchable. That's going to be utilized. That can be utilized by lawyers everywhere in the world. So that's the first thing. The other thing is some of the numbers are very large in terms of a litigation budget. So what we would like to do is to give you a full range of possibilities of what things are going to cost in each jurisdiction, because I think that's an important decision or discussion you're going to have with your board. Now, obviously, from what you've heard today, that getting initial success is really important. And we've got the consensus view that the best place to obtain an interim injunction is going to be in Germany. And so what we'd like to do is start getting ready to bring that action in Germany as well. Alex, did you have anything else to add?
No, I think that was a great summary. Gordon, did you have any questions for anyone?
Well, I have got some questions for a few people. I'd just like to sort of pick up my own sort of thoughts generally overall on what I've just heard first. I mean, it seems to me as though all the jurisdictions we've just discussed have got, to some extent, their own advantages. I really like the speed to final injunction, the speed to trial that I'm hearing about from China and Russia. and I like the costs in China and Russia as well. As a, you know, those both sound eminently affordable. I'm not sure in my particular case that either China or Russia is the optimal place to start, because I'm not sure that a judgment gain there will have the impact around the world that I would like. I think if there was mass infringement in one or two venues, then that might be really excellent. But you know, for these purposes, I prefer to think of maybe something that'll have a little bit more impact. I really like the sound of the CESI in France. I like the idea of getting this evidence that I can then use elsewhere, because I know that the disclosure rules in the UK, where I'm resident, and I've had a lot of experience in the US, I know that there are limitations on what you can do with disclosure documents from arising in either of those countries. So it's really great to hear that disclosure documents in France might be usable elsewhere. And that alone, you know, actually makes me wonder whether, in addition to anything else we decide, maybe I might say, well, I'd quite like you to kick off in France so we can get a lot of stuff together. Obviously, I'm paying you for your advice, and Germany is, of course, very well known as an interim injunction jurisdiction, and I've been on the wrong end of that previously, so you know, I understand exactly what can happen and what can be achieved there. In terms of sort of huge global clout, then I don't really think you can beat the UK for a judgment. I think that the quality and the thoroughness of the litigation procedure in the UK, and if I may say so, the fact that it's not dependent on a jury, that you just have an extremely skilled tribunal, you have highly specialist counsel, you have highly specialist, normally scientifically qualified judges. You know, I have placed a lot of faith by that. So it's fascinating to hear what I've heard. I will take your advice, subject to, I think, my possibly saying, well, I'd want to go in France as well, because I like the idea of the CESI. I like the idea of the evidence that I might gain, which might give me a lot of leverage in other parts of the world. So that's terrific, and thank you very much indeed. A couple of specific questions. I have heard of things called utility models in both Germany and China. Could I hear from Jonathan and Jamie on the subject of utility models?
Sure, yeah. I'll just go first.
I'll follow up.
All right, okay. So yeah, that's actually a good point. I mean, utility model protection is something that can be an interesting strategy in addition to patent litigation in particular. Now, what that is it's basically a full IP right relating to an invention. And the interesting thing about utility models is that it can even relate to the very same invention of a pending patent application. And so we could then basically branch off a utility model and just register it within a couple of weeks. So that would give us a right to start an attack based on an invention, actually, that in terms of patenting is still in the process of the application. So this is a great, or can be a great strategy in order to stay or get ahead of competitors, potential infringers. Yeah, especially if there's a tendency of imitation. So we should definitely take a closer look to your portfolio and see whether there are any interesting pending applications relating to that technology, and consider that.
Thanks very much. Jamie, what's the China position on this?
Okay, well, not too much to add actually from what Jonathan said, because in China, utility models seem pretty similar to that which has just been described. And indeed, it is a well-known prosecution methodology that if you want to get quick protection, often you will file both a utility model and an invention patent on the same day. The utility model in China has a benefit that it doesn't need to be substantially examined, and therefore you can usually get protection within 6 to 9 months, whereas with an invention patent in China, you're probably talking 2 to 3 years. So as long as it is a structural invention as opposed to a process, which models in China do not cover, then it's a really useful strategy to consider, and one that is has many advantages. So it's certainly something to talk about. Thanks
very much. Another topic I'd just like to ask a question on before we sum up at the end is this. I have been involved in patent litigation. I have a lot of experience in the field, and I know the value of expert evidence. I know how decisive and how influential expert evidence can be. Of course, I'm very conscious that in the UK, in Canada, and in the USA, the use of independent experts is common. I know that in Germany it isn't, that there tends to be a court-appointed expert, and I know that experts are not a big deal in China and Russia either. But bearing in mind the soft spot that I have developed during the course of this discussion for Paris, Clémence, can you tell me what is the position on the use of expert evidence in France?
Yes, before French court, expert reports are not only authorized but also recommended. The fact is that even though patent cases are handled by specialized judges, they have no technical background. So it is very important for us to explain the invention and make the infringement transparent for the judges. And in this respect, we have indeed the expert report option. It can be court-appointed experts that have the authority of being registered with French courts, but it can also be private experts reports, which we know are very useful. And French judges will have no objection to rely on foreign expert reports, for instance, as long as the said expert is qualified in the field of the invention, and as long as the report is translated into French. So I think this is an authorized and a recommended piece of evidence.
Thanks very much indeed.
Alex, can I ask you in terms of a retainer, can you just explain the process of an upfront retainer for a large litigation file like this in terms of your practice?
I mean, as Patrick, as you know, as a firm, we don't operate any set policy on upfront retainers. It all depends on the case in front of us. So, you know, if there's an immediate, very significant outlay of cash, then we will often ask the client for the money for that. But we don't tend to ask for money on account of fees. And by an immediate payment, I'm thinking of something like, you know, hiring a team of private investigators to travel to the coast in whichever country to obtain evidence of infringement, or, you know, having to retain a testing house to commit, you know, litigation level tests on something before we commence litigation.
Let me tell you as the client, what I don't want to surprise is, I know patent litigation is expensive and I'm going into this knowing where I'm going. I want you to be upfront with me about your estimates around the world. I then want regular billing. I don't want big surprises. I want to be billed on a regular basis so that I can see how you're doing against those budgets. And if there's something that happens along the way that derails the budget for whatever reason, I want to know about it immediately. And those are the core things. And I know that as a firm, that is what you do. So that's why I'm here having this conversation. Last question from me is about appeals. You know, am I going to get unseated by appeals here? Am I going to get delayed? You know, if I've been successful at first instance, what happens to my judgment if I'm appealed? Any particular comment from anywhere on that? I'll just hear from one country.
Yeah, Jonathan, do you want to take that one?
Yeah, sure, I can do that. So, of course, the appeal will delay the final infringement decision, for example. But the positive thing to think about here, I think the true chance is that an injunction would be provisionally enforceable, usually. But that means we need to pay a security payment covering potential damages. Can be relatively high. one case I think a lot of people might know is Qualcomm versus Apple, where I think last year, shortly before Christmas, a lot of iPhone models needed to be taken off the German market. And that was because they made a security payment. And in this case, based on a first instance judgment, we can still enforce the injunction for the time being, which can, for a certain time frame, increase the pressure enormously and put us ahead.
Okay, thanks very much indeed. Well, thank you. Thank you to my international panel. Thank you for your advice. Thank you for your considered views, which are extremely valuable. I'm going to just step out of role now back into my usual persona. Thank you to everyone who's attended this event today. We really appreciate your interest and hope that we've been able to give you some real insight into the options available at the outset of litigation. My takeaway message from all of this is it's all about preparation and coordination. Doing the groundwork, interviewing the witnesses, pulling things together early can save you a lot of time, trouble, and money later on. So getting the preparation right is key. And on coordination, many of the pitfalls in multinational litigation come about through people flying solo and not behaving as a team. The key to success is to ensure that everyone knows what is happening and someone is at the center of this, pulling the strings, overseeing the communications, and ensuring that what look like sensible submissions in one country do not have disastrous effects elsewhere. It takes teamwork, and it takes a real focus on what the client wants to achieve, and then ensuring that the litigation team works closely to deliver those goals through a coordinated strategy. And that means that it's not all about just one firm, but when you are working with a team of firms, because not everybody has an office in every country in the world, obviously, that you work with people you know, you trust, that you can talk to and communicate with freely as part of an enlarged single team. Right, next week, we're going to be looking at exactly the same set of events and facts, but from the other side of the fence. We're going to be looking at the defendant's view. In the meantime, a recording of today's event will be appearing on our website and at goexcel.gowlingwlg.com very shortly. If you would like to watch again or share with your colleagues, and I know this is holiday season, so if you've got anyone who's away at the moment and might like to see this when they get back, then you can point them in that direction. Thank you once again for your kind attention today. We look forward to seeing you again, and the broadcast will all close automatically in a few moments. Thanks very much indeed.